room should be provided to the should be maintained, and similarly facilities for sitting, you need to have proper sitting area, resting area. The first aid appliances should be provided, and for every factory where there are more than 250 workers, the state government has made a rule that there should be a canteen which shall be providing the standard food to the employees, and these have to be checked on regular basis. The quality has to be verified, and shelters and restrooms in every factory where there are more than 150 workers, they should be having shelters or restrooms or lunchrooms. And the creches, these are nothing but the child care, where there are more than 30 women workers who are employed. So to maintain under 6 years age children, they need to be having some kind of a child care provision. And in every factory where there are more than 500 workers, there should be a welfare officer who will be taking care of the welfare of the workers. Okay, so it is mandate. And coming to the provisions relating to working hours for the adults, so weekly hours. So the weekly hours are not more than 48 hours, and the weekly holidays should be at least one holiday starting with the first day. That is, the week begins with Sunday, so the first day of the week will be a holiday. And if at all that is a working day, so within 3 days immediately that the holiday has to be substituted. And the compensatory holidays, generally whenever you're working on the weekly holiday or any other rule, so he is entitled for a compensatory holiday equal to the number of holidays he lost in the work. So the daily hours for the adult worker should not be more than 9 hours in any day, and the weekly hours should not be exceeding 48 hours. So it can be 9 hours, 5 days, or 6 hours or 8 hours, 6 days. So that is how it should be. And coming to the resting time, after every 5 continuous hours, there should be an interval of half an hour rest. And moreover, if the total number of hours worked without rest interval, it should not be exceeding 6 hours. So after 5 hours, you need to have a half an hour rest. And under any circumstances, that should not be beyond 6 hours. And the night shift, so whenever the person is working for a night shift, so there should be a weekly or compensatory holidays for a period of 24 consecutive hours beginning the shift. And the following day shall be deemed to be a period of 24 hours off for the night shift or when the shift ends. And the extra wages for the overtime. So whenever the person is working beyond, that is 9 hours in any day or 48 hours in a week, the extra wages, overtime wages should be paid, which is twice the ordinary rate of wages. And so what do you mean by ordinary rates? The basic wage plus the allowances. So apart from that, the double the amount should be the payment to the workers. And the rate of wages, either it can be the piece rate, the number of pieces what he is manufacturing, or it can be time rate, the number of hours he's spending in the work area. And the wages during the leave period. So definitely every worker is allowed for a leave. So generally it is, for a period of continuous 240 days of working, for every 20 days, the worker is going to get a 1 day holiday or 1 day leave. So that is how the calculation is done. So when it comes to the wages during the leave period, whatever the leave period calculations are there, those should be done accordingly. And the definitions have been given. What is a standard family, which means consisting of a worker, his wife or spouse, and 2 children below the age of 14 years. So they all need the consumption of 3 adult consumptions if it comes to the food grains. And adult consumption means the consumption unit of a male above the age of 14 years and the consumption unit of a female above the age of 14 years and the child below 14 years. So it is 0.8 and 0.6 respectively for one adult consumption unit. So payment of advance in case of certain cases where the leaving is not allowed for less than 4 days. And if a child worker for not less than 5 days, so that should be the leave period in advance. And the mode of recovery of unpaid wages will be can be recovered as delayed wages under the provisions of the Payment of Wages Act 1936. Now, coming to the provisions relating to the hazardous process, whenever the person is working in hazardous situations, whether it can be a factory site or any other area, so there is a constitution of the site appraisal committee, which will be tested by there's a chief inspector and the chairman. So they are going to be representing the central board, and they try to verify, they try to check, they try to inspect, and any process relating to any correction will be informed to the management. And there is a compulsory disclosure of the information by the occupier. So whoever owns that land, he needs to give complete information about that particular land or factory, whatever problems or whatever deviations or whatever is the nature of the work, complete information has to be given. And also the occupier has to give the information relating to the hazardous process which are taking place in this factory. So the central government will appoint an inquiry committee to verify, to check, to measure, like what is really happening, what kind of hazardous materials are being processes are being dealt in the factory, and based on that, the emergency standards will be laid, and they try to lay down certain rules regarding the permissible limits of exposure to chemicals and the toxic substance, and these are all governed by the central government. And workers' participation in the safety management, it deals with the workers whenever they are working with the hazardous processes or hazardous environment. The safety committee will try to provide with the information what kind of safety measures they are supposed to take. And provisions relating to the annual leave. So whenever I'm talking about the annual leave, as I already said, so every worker who has worked for a period of 240 days or more in a calendar year is eligible for a leave. And for an adult, 1 day for every 20 days, and for a child, 1 day for every 15 days. And the accumulation of the carry forward of the leaves is accepted, subject to the maximum of 30 days for an adult and 40 days for a child. More than that, you cannot accumulate, and you need to apply for a leave at least 15 days prior to the date. And based on the leave, the approval authority will be checking with the leave reasons, and then based on that, the approval will be provided. And whenever the annual leave with the wages cannot be availed for more than 3 times a year, so if the worker is employed in a public utility services, the application for leave which wages shall be made at least 30 days. So the paid leave at least 30 days before he is supposed to submit an application. So the scheme of leave continuity in the work is always to be assured. So the grant of leave can be regulated. So it should be preparing a scheme in writing, regulating the authority, like how the leaves have to be given. Okay, so based on that, the leaves will be approved and given to the workers. So what are the special provisions? The state government, by notification in the official gazette, declare that whatever the provisions which are relating to the place of manufacturing process with or without the aid of the power will be following that the number of persons employed therein should be less than 10. And if they're working with the age of power, and less than 20 if they are not working with the power. And the process of working therein are not employed by the owner thereof, but are working with the permission. Okay, and what are the rights and obligations of the employees and the workers? So the rights are he can have a safe and healthy working environment. He can have the information about the hazardous and whatever the hazardous products or manufacturings are there, such information has to be dealt. And he can also make requests to change the potential hazards, and he can participate in the workplace inspections, and he can also be exercise no discrimination and refuse to work that puts the employee in danger. And the obligation is he has accepted to work, so he need to follow the instructions and maintain the timings as per the governance given. He has the obligation to pay the remuneration He has the obligation to give the holidays, and he has the obligation to provide good working conditions, safety measures to be provided, good drinking water, and spittoons and urinals, and good lighting area. All these are the obligations of the employer. And then coming to the workers, to the workers, no worker in a factory shall willfully interfere or misuse any appliance, willfully will not put him into any danger or any other person, willfully does not do any negligence during the work. And he has the right to obtain the information from the occupier, get trained within the factory if any requirements are there, and he can represent the inspector directly or indirectly for any other matter. And you also have the offenses and the penalties whenever such duties or obligations are not filled under the Compliances Act. Under the compliances, you need to follow the various procedures, whether it is the payment of wages, application for the leave, or the safety measures or anything. Whenever such offenses are made by the companies, you will be called, and you have to answer for the reasons of such negligence. And there are penalties, and there are also procedures wherein you will be, you'll be imposed a fine of 25,000 in case of accidental death, or 5,000 in case of any other body injury. And apart from that, you might be put behind bars, and sometimes the fine amount, or the term amount can be for 3 years, and the fine might be ranging between 10 to 2 lakhs, or sometimes it can be both. So you need to be very careful, wherein the organizations have to check that whether they are following the rules which are being mentioned in the that is in the rules, or which are laid down by the central government, are followed or not. If there is any default, they will be definitely prosecuted or penalized. And coming to the next subheading is the Trade Unions Act 1926. So what do you mean by a union? A union is nothing but group of workers who form a team and help each other for the issues relating to the work. It can be the fairness of pay, it can be the working environment, or it can be the hours of work, or it can be the welfare measures, or anything. So such kind of facts will be, no, the members will be trying to help each other in getting the justice for these kind of areas. Now, coming to the labor unions or trade unions, these are the organizations which are formed by the workers to provide guidance and to protect the interest of the workers. So, coming to the nature and the scope, the basic nature is they have formed to protect the interest of the workers, and the workers or the labor, they don't have the knowledge, they have poor bargaining power or weak bargaining power. So they want to protect themselves against the employers discrimination, or it can be the any other matter. So for that purposes, the unions as a group, as a team, they want to fight for the justice against the employer. For that purpose, the unions are formed. Coming to the significance, they are the trade union came into being for variety of purposes. So it can be the individual workers, or it can be the group of workers, it can be the trade related workers, or it can be the manufacturing related workers. So as I said, the weak power of the worker should not be manipulated or taken as an advantage by the employer. So it protects the economic interests and certain amenities, certain benefits, certain wages. And there's a platform where the worker can raise his voice against the injustice against the employer. So what are the objectives? Now you have the economic objectives, that is to provide fair wages, fringe benefits, security to the jobs of the employees, provide good working conditions, improve the productivity and the development of the employees, and so on. You also have non-economic objectives, that is where you try to instill the sense of social responsibility, and you try to influence the socio-economic policies of the community. You contribute towards the community development, you strengthen the political power. So in a way, you promote the national integration. So coming to the characteristics, it is association of employees. So it can be teachers association, it can be doctors association, it can be weavers association, it can be workers. Depending upon the employment and the profession or the trade or industry, you can have unions, and it is a voluntary association where people will join free of will, and it's a permanent body. Once it is set up, it's a permanent body. The other cases is it can be either registered or unregistered trade union, and the people who join there have common interests and they strive to achieve these common interests, and it is a collective action, and they try to develop a rapport with the management. And basically, the trade unions' functions are to secure fair wages, safeguard and protect the interests of the workers, good working conditions, provide educational and cultural and recreational facilities, and trying to provide good working and living conditions. Offer good cooperation amongst the workers, and in turn have a good rapport with the management, and also to develop individual and collective welfare. Coming to the structure of the trade unions, we have the craft. There are altogether 4 classifications which are based on craft basis, general grouping, industrial unions, and federations and confederations. So crafts, based on the job they do, they form a craft, and they try to start a union. So the examples can be the drivers association, it can be the lorry drivers, or the union of cab drivers or auto drivers, and you have the signaling staff union or the Indian Railway. So depending upon the craft what they do, you can have an union. And the general union, generally it has it is for the occupation, whatever they are doing. Generally, the industries have the employees union. It can be the Jamshedpur Labor Union or Thane Industry Union, so on. And industrial unions, these are the vertical unions, whereas the craft unions are horizontal. So where they have the common interests, the common problems for all the same industries. So such will be the industrial unions. And the federation and the confederation unions are those which are generally formed with the strengths. So, the associations, in order to improve the trade union unity, you form into a federation, and you try to act on the basis of the federation. So the Federation of Indian Railways or the PNT, central government employees, okay? So this is the telecommunication. So in that way, you try to have such kind of federations. So what are the types of trade unions? It is based on ideology. It can be the revolutionary. They believe in the destruction. They always think that the existing social economic order is based, and they try to create a new one. Or it can be a reformist, where they want to reform the existing socio-political framework. Or it can be the uplift unions, where they advocate extensive reforms, and they go beyond the area of working conditions. And based on trade, we have the structure of the trade unions depends upon the memberships and the jurisdictions based on the trades they represent. Okay, so it can be the agriculture or forestry or forest workers union. So they are pertaining to a particular trade. And they next can be the agreement, where you have the closed shop agreement. So what is a closed shop agreement? Where management and union agree that they would have a solo responsibility and authority for the recruitment of workers. So the workers join the union to become an employee of the shop. So it is relating to the shop affairs. It can be the union shop, where there is an arrangement that all the new recruits must join the union within the fixed period. Or it can be the preferential shop, where union member is given preference in filling the vacancy. Or it can be a maintenance shop, where the arrangement, there is no compulsory membership in the union, but the employee chooses to become a member, and after the recruitment, his membership remains compulsory. And then you have the agency union, where there's an agreement between the management and union or a non-union member, so that they can be the equivalent membership subscription is there in order to continue the employment. And then you have open shop. The membership is a union in which there's no way of compulsory or obligatory. Either it can be the before or after. So before recruitment also there is no obligation, and after the recruitment also there is no obligation for you to for the worker to stay. So generally the advantages, it saves the time, it protects the interest, there is mutual trust and respect for each other, there is cooperation, and that also encourages changes in the working practices. But sometimes there's also delay whenever there's a union. The group of members go there and they talk, and I mean the bargaining does not end at one go. There is continuous decision making, differentiation, and coming to the practices also, where there is no closed shop, where I mean where everybody is not required to present. So whatever the decisions are taken might not be accepted by everyone, and more number of unions will be resulting in delay in the process, as well as that will result to the disputes, and unreasonable demands are also can be made because of the union part. The workers think that they can ask for anything. Coming to the next one is the Trade Unions Act. Now, the Trade Unions Act was passed in the year 1926. It was in the Buckingham Mills case of 1920, in which the Madras High Court granted an interim injunction against the strike committee of Madras Labour Union, forbidding them to induce certain workers to break their contract of employment. So, trade unions leaders found that they were liable to prosecution and imprisonment based on this case. So in March 21, Mr. N.M. Joshi, he was the General Secretary of All India Trade Union Congress. He successfully moved a resolution in the Central Legislative Assembly to introduce and protect the interest of the trade union. So that is where the Trade Unions Act was passed in the year 1926, and the act extends to whole of India. Now, coming to the definitions, executive means the body by whatever name it is called in the management. Office bearer is the person who actually is the member of the executive body. And a registered office means a place where the trade union has been registered. Registered trade union is registered under the Trade Unions Act 1926. Trade dispute means a dispute between the employers or workmen, or between the workmen and workmen, or between the employers and employers. So these are the three actors or the participants in the industrial setup. So any dispute amongst them will be considered. A trade union can be a temporary or a permanent combination of people who work for the benefit of the workers or the members. And the registration of a trade union, it is generally not compulsory, but it is always good that if your union is registered. So there is a mode of registration where you need to have at least minimum number of 7 members to register a trade union. And the application for the registration has to be given along with the names and the occupations of the members, and the titles and their ages also. So they have to frame down the rules for the registration. That is, what is the name, what are the objects, why did it form, so maintenance of the list of members, and again in what way you are admitting the new members, whether it is honorary or temporary. Okay, the how much is the subscription they are paying, and the manner which the rules are being amended and follow up. So how the trade union can be closed or dissolved. So all these things have to be mentioned. And once the registrar will be checking the details, he'll then register the trade union. So the trade union will be given the certificate of registration. So once you have the certificate of registration, you have the authority. I mean, it is advantageous where you can become a body corporate, and you can have a separate seal which shows that the separate existence is there. The union can acquire both movable and immovable property. It can enter into the contracts. It can be sue, or it can be sued. Okay, so whenever you want to cancel the registration, you need to apply or you need to go for a withdrawal of the registration. So you need to submit an application. And once the application is submitted with all the due requirements, within 2 months, the registrar, if nothing else is mentioned, will serve the cancellation. Now, coming to the trade union rivalry, so there is no restriction between the number of unions which can be formed in the industry or in an organization. So the minimum number is 7. And so anyone who have minimum of 7 members can start a trade union. And multiplicity of the number is also there, where one member can be a member of several trade unions. So in that case, what really happens is there can be a conflict, there can be a rivalry, and people will be fighting for the same cause under different trade unions. Okay. So coming to the rights of, it's a body corporate, it is registered, so it needs to follow all the rules regarding to the salaries, expenses, allowances which are being paid to the office bearers, and whatever the expenses they are incurring should be maintained in the register. Periodical meetings should be conducted. The members should be aware of the various governance which is going on in the trade union. And you need to have a separate fund for the political purposes. And the criminal conspiracy in the trade disputes, no bearer or member of a registered union shall be liable to punishment. So if he is liable to punishment under IPC, he cannot be a member of the trade union. And protection against the civil suit whenever there is any legal proceedings going on. He can appeal for the protection, and enforceability of agreements is there. Every member has right to inspect the books of the trade union, and a person who has not attained the age of 18 may be a member of a registered union as per the rules, but I mean, he cannot be pulled into all legal things whenever there's a minor entered into the trade union. Okay. And the dissolution process, as I said, you have to dissolve it by following the procedures. And coming to the penalties, whenever a trade union is providing falsifiable information or it is failing to submit the return, okay, so or if there is any cognizance of offense, definitely they will be penalized. Penalty will be levied against them, and they might in some cases they might be charged a penalty of up to 200 rupees or 500 rupees or 50 rupees per offense in that way. So whenever we are talking about the economic reforms, yeah, we have the economic reforms of LPG, liberalization, privatization, and globalization. So all these have reformed our country in most of the ways. So similarly, the same encouragement is given to the trade unions as well for the modifications in their rules and the performance. So we have national level federations of workers and the trade unions. So what are national federations? Where you have performing activities at the national front, irrespective of the industry to which you belong. Okay. So we have Indian National Trade Union Congress, INTUC. So it is an unified council with several branches and with several councils functioning under direct control and the supervision of the central organization. So you have Federation of Unions like Hind Mazdoor Sabha, All India Trade Unions Congress, the United Trade Union Congress. So these are all the federations of unions. Now, the theories of trade unionism, Hoxie functional classification of unionism. So, this theory of the labor movement has came in the year 1920. So, it is started in United States, and basically it is a business unionism which will be protecting the interest of the various craftsmen. So, to uplift and uh, try to be the protector of the unionism is the basic function. Then we also have Webb's theory of industrial democracy. So the Webb's theory, the goals are that the workers are not only economical but also political. So the Marxist theory of the trade unions have two goals. It is the short-run goal as well as the long-run goal. So the short run can be the day-to-day struggle of for the wages, for the working hours, and so on. Whereas the long run, it is the prosperity and having a good economic and stable life. And coming to the revolutionary theory by Marx and Engels, we have this theory proposed on Adam Smith's theory of labor value, wherein they try to focus on that every trade union class or consciously or unconsciously has to involve in the political action. So in a way, they try to compel the political activities wherein you can strengthen your trade union movement and get the justice. So we also have Mahatma Gandhi's theory of trusteeship. So Mahatma Gandhi, who served Ahmedabad Textile Labor Association, he believed in Satya Ahimsa. So based on this trusteeship, where you feel like you are the trustee of the organization, you try to safeguard and protect the interest of the union. So in that way, you can deliver justice and get the justice. And you also have employers organization. So trade unions protect the interests of the employees. So you also have employers organization who work under, who manufacture under same heading or same industry, will try to protect the interests of each other. And then you have the next criteria: employment exchanges and compulsory notification of vacancies. So what do you mean by an employment exchange? It refers to an office of the central or state government which collects and furnishes information on the prospective employers. So whatever the employer details are there, the job openings, the job opportunities are there, those will be mentioned in the employment exchanges. So the Employment Exchanges Compulsory Notification of Vacancies Act 1959 says that in private sector or public sector establishment, the employers used to fill the vacancies in their establishments by their own choices. But the persons who are registered with the employment exchanges are never called. So the Employment Exchanges Compulsory Notification of Vacancies Act has suggested that whether it is a private or a public sector, for public sector, it is compulsory that they have to hire the people who have registered with the employment exchanges. So the definitions: employee means a person who is employed in an establishment, and employer can be any person who employs one or more people. And an employment exchange is an office or a place established where the government, they try to collect the information and seek the information from the prospective people who have the eligibility to work, and supply the same information as and when the vacancies arise. So establishment means it can be an office or place or an industry where people can work. So establishment in public sector can be, it is owned and controlled or managed by the government, state or central, or it can be a corporation, or it can be any local authority. And you also have a private sector where 25 or more persons are employed to work for a remuneration, uh, not in a public sector, are considered as a private sector. Now, coming to the objectives: to assess the employment potential in various establishments and categories, and you also to have a better appreciation of the labor market. So the Act extends to whole of India, and it shall come into force in a state where the central government may, by notification in the official gazette, deliver such. So the applicability is in agriculture, in domestic services, and for every employment where the duration of the employment is for more than 3 months. It can be the unskilled office work like peon or watchman or sweeper, or it can be connected to the staff of the parliament. Okay, and who carry a remuneration of rupees 60 for a month. Okay, so notification of vacancies of the employment exchanges. So every employer needs to gather the data of the vacancies which are going to arise in their in the industry or organization, and then they need to submit such information to the official gazette within the appropriate date for the notification. And whether it is public sector or private sector, they try to give the details furnishing pertaining to their classes of the employment, and the information will be submitted to the employment exchanges. So here, the section 6 empowers that every officer of the government may be a person who is authorized in writing to access any relevant record or document which is in the possession of the employer and wherein he requires any additional information. And whenever the employer fails to notify the employment exchange, which is prescribed for the purpose of any vacancy, is punishable. So it can be a fine which might extend to 500 rupees for every subsequent offense, and which might be extending up to 1,000. So whenever the employer fails to furnish the information or refuses to furnish the information or provides falsifiable information or refuses to answer, so this kind of penalty can be levied. And under Section 10, the central government has power to make rules. It can be about the employment exchanges, or it can be the form or manner in which the intervals at which the information should be supplied. And it can be the officers by whom the manner in which the right of access of the documents or the entry can be given, or any other matter which depends upon. And all the rules made under this act shall be laid for not less than 30 days before each house of the parliament. Now, coming to the Apprentice Act 1961, the industrial development of any nation, it depends upon the development of the human resources. So, the Apprentice Act 1961 was enacted to regulate and control the program of training and apprentices. A person who is learning a trade from a skilled employer, having agreed to work for a fixed period at low wages. So an apprenticeship is a program which trains the worker. So apprenticeship is a training program. And this program will enable the worker to, to get the skill so that the same skill can be delivered. Okay. So apprenticeships are combine hands-on work and as well as the classroom training, and these are considered as full-time employment. So you cannot learn the work. See, the moment you apply for a job, they generally ask, are you trained or do you have any experience? So that problem can be ruled out whenever there is an apprenticeship training where the employee can be trained and even the stipend is provided during the training period. And generally it is borne by the government, and the apprentice is also the minimum apprentice part which is paid to the apprentices. Apprentice means a person who is undergoing apprenticeship training in pursuance of a contract, and the training which is provided by an industry or establishment which is in pursuance of a contract of apprenticeship. And you will be a designated trade means a trade or occupation or any subject in field of the engineering. An employer is a person who actually employs the person more than one. Establishment is an industry where it consists of different departments or branches. A graduate or a technician apprentice is a person just a second. So an apprentice person is generally a person who actually deals with the people who actually join for the purposes of training. And an industry means it is a concern who actually delivers the trade. Technician, vocational apprentice means an apprentice who holds or is undergoing training. And then you have trade apprentice, which means an apprentice who undergoes apprentice training. And a worker means who's a person who's employed for the wages. So the objectives of Apprentice Act 1961 are to provide training to the candidates so that they are well versed and they can work once the training is completed. So this act applies to whole of India, and candidates holding diploma and engineering graduates can be considered for the benefit of the plan. And the act should control the screen and the preparation of the students in exchanges and whatever the issues which are related to them. So there are 38 sections which are scheduled in the act, and this schedule is in regards to the adjustments in the Workmen's Compensation Act 1923, and it is applicable to the students under the Apprentices Act 1961. Coming to the applicability, it is applicable to all the industries and trades which are informed by the central government in the official gazette. So what are the qualifications? A person shall be qualified for being engaged if he is not less than 14 years of age and he satisfies such standards or education which are prescribed in the physical fitness. So the contract with apprentice, no person shall be engaged as an apprentice to undergo apprenticeship training in a designated trade unless such person, if he's a minor, his guardian has entered into the contract of apprenticeship with the employer. So either it is, if it is a minor, the guardian should enter, otherwise the person can enter into the contract of apprenticeship. So what are the duties to learn the trade? to learn the techniques, to attend the classes regularly, and before the expiry of the training period, he needs to accomplish the training skills. And whatever the practical or instructional classes are there, those should be attended regularly. And he have to follow the lawful orders, what the employer or the superiors give. And he also has to carry out the obligations under the Contract of Apprenticeship Act. Now, coming to the responsibilities of the employer, he needs to provide the apprenticeship training to the apprentices who have been appointed. And if the employer is not himself qualified in the trade, then he should ensure that he's appointing a qualified person to provide the training, and to provide adequate instructional staff, material, or the environment where the apprentice can be trained, and to carry out all the obligations under the contract of apprenticeship. And novation of the contract. So what does this mean, novation? So this is applicable if the promise is not kept under the agreement of the apprenticeship advisor's consent. It is accepted by the apprentice. So once the rules, whatever the governance are mentioned in the apprenticeship contract, if they are not being justified, if they are not being fulfilled, then the within the period of expiry, the novation of the contract, that is the cancellation of the contract, or the contract ceases to be existing, it can be categorized. Okay, so coming to the welfare of the apprentices. Apprentices are trainees and they are not workers. So the employer should always keep in his mind that he cannot give orders which cannot be dealt by a apprentice. He's only a trainee, he's learning. So the records and returns, whenever employer is required to maintain the records of the progress of the training, they should be furnished, they should be maintained. The detailed note should be available, and the payment to the apprentices should be returned in the book, and it should be, whatever the stipend, payment to this is the stipend, whichever is being paid, should be recorded with due signatures. And the hours of work, overtime, leave, holidays. So as per section 15, the weekly and daily hours of work for the apprenticeship should not go beyond the mentioned time. And also, if any overtime is done, if any leaves are pending, such should be provided to the apprentice. And you need to conduct the discipline. So you need to follow the rules. It is not easy that you can do whatever you want when you're getting training. So all the rules, the code of conduct and the discipline should be followed. And as per section 20, if there is any disagreement, if there is any dispute, it should be settled between the employer and the apprentice. That is the relationship which has arisen out of a contract should be referred to the apprenticeship advisor for decision. So who are the authorities under the Act? You have the National Council, you have the Central Apprenticeship Council, the State Council, State Apprenticeship Council. So these are all the councils which are the authorities under the Act, where the aggrieved people can approach and resolve their conflicts. So conducting the test and grant of certification and conclusion of training. So as per the subsection 1 of the Act, every apprentice who clears the apprentice test shall be awarded a certificate of skillfulness in the trade of by the National Council. And the employer will evaluate the development and then give a vocational apprenticeship periodically. And after successful completion, so he can be called as a vocational apprentice, or whatever the title is there, the title will be given where the proficiency will be judged, and he can be appointed wherever possible. So the termination of contract on completion of the duration of the apprenticeship training, whatever the contract the employer and the apprentice has entered will be terminated because he has already completed the training and he has received the certificate of completion. And coming to the offenses and penalties, whenever there are any offenses, like when it comes to the terms and conditions of the contract, or it can be the apprentice person who's not qualified in teaching, or if any further information is required to be furnished, all these things come under the offenses and the penalties, so which will be taken care by the respective authority. And for any of the default found, he'll be punishable and also imprisoned for a term of not less than 6 months. And then a fine might also be levied. So whenever the offenses by the companies are dealt, so there's no distinction between the apprentice and the company. So even the company will be penalized for the negligences, whatever have been dealt under the Apprenticeship Act, and they will be penalized as well as prosecuted as well. So nobody can escape the law. That is what that means. And the amendments to the Act and the significant changes. So the amendments were to include the agency workers and the contractual workers as well. And the amendment to the Apprenticeship Act has paved way for the transformation of all the conventional methods, wherein you try to record everything on the electronic records. And due to the amendment in the Apprenticeship Act, there is a change in the procedure of checking. I mean, how to strengthen the apprentices of the to be employed. And if there is any violation, yeah, there is the constructive authority which will try to protect the interests of the apprentices as well as the employed organization. And any default, whichever is found, that will be dealt under the Act, and they will be penalized and prosecuted. So this is where we try to enter this particular section. The next is the industrial employment standing orders, which we will continue in tomorrow's session.